I do agree that it's going to get better for a certain segment of landlords. And that segment of landlords, admittedly, is larger owners. The regulations are going to become so difficult to navigate for mom and pop landlords that they are going to end up selling these buildings to much larger companies.
Hi, this is Chris German. Welcome back to the Apartment Dealer Show. With me today, I have Mr. Mike Brennan, Eviction Attorney Extraordinaire. Now, this is part of our interview series as we introduce or reintroduce you, the viewers, to the panel of speakers that's going to be partaking in our upcoming Apartment Owners Educational Luncheon. This, of course, is a live event where I bring together professionals from the areas of real estate law, taxation, market forecasting, commercial lending, and all the rest to update the owners. What's changed year over year? What is about to change? What changes are pending? And what information do landlords need to know that will impact how their multifamily portfolio performs? That is the purpose of this live event. Mike is one of the speakers involved, of course, discussing all things when it comes to tenant evictions and rent moratoriums and all the rest. We took a survey of those landlords that own in our area of service. What question would they pose to an eviction attorney if given the chance? What issues are they having? Then my staff and I sifted through those, took out the questions that were most common that were coming from the landlords time and time again. And those are the questions that Mike and I will be discussing today. I know you're going to find today's sit down informative. And with that, help me welcome Mr. Mike Brennan. Mike, welcome back to the show, sir.
Thank you, Chris.
So, of course, we're going to graze over, because I know with each of these questions, given your experience, your depth of knowledge, we could do a deep dive. But the purpose here is for these individuals who submitted these questions and for those that are maybe dealing with the same issue, at least to get some starter information, know what direction to look towards, and of course, then they can reach out to you or a local eviction attorney to really resolve the issue. But I appreciate you, being with us. I appreciate your time.
Thank you, Chris. I appreciate you inviting me.
So the first question here is, what do you do with these tenant attorneys who continue to postpone, 2 and 3 times, and they won't come to, they postpone asking for a jury trial, and then essentially in the 11th hour, they always agree to some type of settlement, but they're trying to drag out the process to give the tenant more time in the unit and what have you. How do you address that?
First of all, you're exactly right. Most tenants don't have the money to move, and so the tenant's attorney's goal is 180 degrees opposite of the landlord's. It's to keep that tenant there as long as they possibly can so that tenant can save money so that they can. Ultimately, these cases end up settling. The only effective way that I have found to hold the attorney's feet to the fire, so to speak, is to prepare for a jury trial. When they demand a jury trial, you immediately do your jury documents, submit your jury documents to the opposing attorney, and kind of start pushing them in the direction that, hey, we're not going to even attempt to negotiate, we're just preparing for a trial. That's how you push them into actually a negotiating situation.
Of course, with individual cities having their own versions of rent control and eviction moratoriums or rent moratoriums and what have you, the landlords are getting lost of, okay, well, I own a building in a particular city, in a particular jurisdiction, in a particular county under the state. And so it's hard, right, to know what to do. So this question is very simply, are we allowed to evict in LA County? So we're going to assume this is the incorporated part of LA County for non-payment.
The short answer is yes, you can. One of the unique aspects of the county's moratorium is that it used to actually prohibit certain things, and now it doesn't say that. As a result of the federal lawsuit where the county lost on a ruling in there, they had to modify their moratorium so that it says you can file the eviction, but the tenant can raise the moratorium as a defense. So the other unique aspect is The only people protected under the county's moratorium right now are low-income households. So in 80% of the cases, if you've got a tenant who's not paying rent right now, serve the notice and file the eviction. There's certain criteria. I don't want to take too much time and go too deep into this right now. We can cover this at the luncheon, all the criteria. But the short answer in LA County is yes, you can file evictions for non-payment of rent right now.
And if you're working with the right eviction attorney, he'll know those stipulations that essentially does your case qualify, right?
Correct, yes.
Got it. Can you now ask someone to move from unincorporated LA County if your intention is to do a substantial renovation?
No, not right now. The county's moratorium expires, well, it's supposed to expire March 31st. For the first time, I actually think that we may hit that mark and it may actually expire. But right now, you are not permitted to do what's called a no-fault eviction anywhere in LA County, including the unincorporated.
So then, let's say the LA County eviction moratorium expires. Of course, the Board of Supervisors has been drawing up their own rules. Do we know, do they have something that exists that speaks specifically to substantial improvement?
Well, now you're getting into a difference between the moratoriums and the county's RSO ordinance. And so, yes, every RSO ordinance has demolition or a significant repair ability to do evictions. Question is, does the landlord meet that criteria? And a lot of the criteria are significantly harder to meet than the state's AB 1482, what is also referred to as the Tenant Protection Act. And again, this is one of those topics where we don't want to go down the rabbit hole right now. This is the kind of stuff I'll be talking about at the luncheon. But the short answer is right now, anywhere in LA County, you cannot terminate the tenancy for a substantial remodel.
This landlord asks, can I evict my tenant for nuisance and threatening of the landlord staff in Los Angeles City? A piece of this is they also recently discovered their tenant, this particular tenant, is on the Superior Court vexatious, I hope I'm saying that right,
vexatious litigation.
Litigator list. And would that help their case?
So the vexatious litigation, no. That's funny that their tenant is on that list. To be labeled a vexatious litigator, you have to file a multitude of frivolous lawsuits against other people, and then you get labeled a vexatious litigant. In this case, it would be the landlord filing the lawsuit against the vexatious litigant, and so it's not going to help them that they're on that list. That list is to prevent the tenant from filing lawsuits. But for a nuisance, again, you have to apply both the city's and the county's moratorium. The city's moratorium, yeah, you can file a nuisance, terminate the tenancy based on a nuisance right now. But the county's moratorium, that nuisance is very narrowly tailored to allow you to do that. It's got to be something that directly affects the health and safety of, for example, the building or the neighboring tenants, something along those lines. So if it's a nuisance where, for example, they're playing loud music late at night and it's upsetting the other tenants, no, that's not affecting directly affecting the health and safety. If it's a nuisance on the other hand where they beat somebody up on the property or they're lighting fires out in the common area, yes, that would be a direct health and safety issue. And yes, you could evict even under the county's moratorium for that.
You know, it's sad that they utilized COVID, which was a tragic thing for many, but they utilized this to put these crazy limitations in place that somehow COVID and people's financial troubles that came from that and medical troubles somehow equals, well, you can be a nuisance in some instances and you can't in others, and you may be able to stay in a unit for some instances and not for others, when it has nothing to do with, if we remember the origins of where these, they say these moratoriums or why these moratoriums were put in place, we've long lost sight of who they intended to protect, for sure.
You're right on the money, and you actually alluded to something a few minutes ago when you were talking about the county supervisors. Their latest move is they have a homelessness issue, and what they have suggested now is they want to move they know COVID's expiring. Even the county is expiring its state of emergency as of March 31st. So COVID is, I won't call it in the rearview mirror yet, but it's getting there. So in light of that, what the county supervisors are proposing is to take the tenant protections that existed under COVID and attach them to the homelessness crisis that I'm sure you remember Mayor Bass just declared a state of emergency in the city of LA for homelessness. So the county is trying to move the COVID protections, make them, in my opinion, trying to make them permanent, and to do it because they can't do it with COVID, they're now attaching them or trying to attach them to the homelessness emergency.
I don't envy your job right now, Mike. Trying to parse through all this stuff. All right, next question. This landlord just purchased a rental property. When they took possession, 2 units were vacant, 1 was occupied. It's a 3-unit property. 2 were full, 1 was occupied. And apparently when they purchased the property through the due diligence phase, they didn't receive any lease agreement or any documentation for this tenant, who now, of course, is refusing to pay. How do they get them out? And before you answer that, Mike, I'm going to jump in here. So for you landlords, strangely enough, some owners do not have any rental agreements for their tenants. I sold or represented owners who sold apartment buildings over the course of last year, 2 sizable buildings, 2 different owners last year, who had no rental agreements, not a one, for any tenant. And it was more of a handshake deal that they had with these tenants. Essentially, they promised to pay rent, I guess. And so the buyers, when they took over, we had all the tenants and the seller sign what's called an Estoppel certificate. And I won't get into all the details here. We have a video that discusses Estoppel certificates. We'll put a link to that video. But if no lease agreement exists, you can't force the tenant's hand to now sign one because you're selling the building. But you can have the tenant request the tenant to sign a tenant Estoppel. And if the tenant refuses to sign the Estoppel, at least have the seller sign the Estoppel so that you have something to fall back on should it come to be that actually the rent was recorded inaccurately, the security deposit, how many people live in the unit and who they are, what have you. You want a tenant Estoppel. So now I'll turn it back over to you, Mike. How do you get this person out?
To clarify, it sounds like you're saying that not only is there no lease, but there was no Estoppel in escrow. Is that correct?
And they're not paying. So now what do you do?
I would go to the seller right away and say, okay, whether they're paying or not right now, how much are they supposed to be paying? I'm assuming have they owned this for a long time? Have you mentioned that?
Sounds like they just purchased it.
Yeah.
And it sounds like they knew how much they were paying, but the tenant decided to stop paying, of course, as soon as they took over.
Yeah. So I would go to the seller and I would ask the seller, how much are they supposed to be paying? And when's the last time they paid you rent? The worst case scenario, if you can get some sort of an estimate on what they were paying, you would serve a 3-day notice just for the amount of rent that accrued since they purchased the property. And that would be perfectly acceptable. You may be surprised when you serve that notice that they actually pay right away, because in their mind they say, well, I actually owe quite a bit more. I'm only getting a 3-day for 1 month. Let me pay and get on track. But before you serve that, you've got to know how much they owe each month. And it sounds like they don't have that information. They're going to have to go to the seller and ask the seller. Alternatively, and I'm not recommending you do this, it's just an alternative solution. You could file an eviction or serve a notice based on the average monthly rent, and the tenant will probably fight you in that. And in that case, you could do discovery and ask the tenant, how much are you supposed to be paying?
Yeah.
I'm assuming right now that they've tried asking the tenant, and the tenant just refuses to tell them. If they haven't tried that yet, start there, then go to the seller, and then worst case scenario, you file an eviction and hit them with discovery to determine how much they are supposed to be paying.
Now we move over to Section 8. I thought this was an interesting question. Number 1, so let's frame it this way. Let's assume there's no limitation within this particular city and county on vacating tenants to do substantial improvements. So let's just assume that's the case here. So the question falls only on the Section 8 component. Number 1, can you give a notice to a Section 8 tenant because you plan to substantially remodel the unit? And if you can, because a part of that provision is that you reimburse them their last month of rent, would you reimburse the full month of rent to the tenant, even though technically they're only paying a portion and housing's paying a portion?
So let's start with the can you do it? Under most HAP contracts, which is a housing assistance provider, you are allowed to terminate the contract for what is called business reasons. So if your business reason includes renovating that unit, then yes, again, as in your hypothetical, you said there's no controls, no rent controls or anything like that. So yeah, you would be able to terminate that tenancy for a substantial remodel, but you would have to give them the 90-day notice rather than a 60-day notice, because that's what's required under Section 8. Okay. Now, as to the question of how much of their rent do you waive, you would waive their portion of the rent in the notice. And then you would tell Section 8, hey, we're terminating the tenancy. We don't want payment as of this date. Now, I will tell you that the Section 8 payment is a completely different contract than the rent, and there's case law on this that establishes even if you terminate a tenant's tenancy, the landlord is allowed to accept Section 8's portion of the rent. You just can't accept the tenants.
Wow, I did not know that. If a tenant had an issue in their unit, a maintenance issue, just repaired it, do you have to wait 6 months from the date of that repair to issue some sort of eviction for any number of reasons? In other words, is there a time frame here you want to wait so that the tenant doesn't claim that, well, this is retaliation. I asked you to fix this in my unit, and now, lo and behold, you're evicting me. You're just making this up. And this is really retaliation. Is there kind of a go-to on that in terms of the time frame?
Sure. There's two different aspects of this. If you are evicting for non-payment of rent, the retaliation code specifically states if a tenant is in default of rent, they're not even permitted to raise retaliation as a defense. So that's one aspect. But let's say you're terminating the tenancy for some other reason. The code also says that if you state the good faith reason in the notice, the burden shifts to the tenant to actually prove you're retaliating rather than it being on you to prove you're not. So in some jurisdictions, you're not required to state a good faith reason. You can just serve the 60-day notice. But if the tenant has complained, you've gone in, you've made the repairs, and you want to terminate the tenancy for a legitimate reason, I would simply suggest you put the good faith reason in the notice and shift that burden back to the tenant.
Back over to Section 8. So this landlord requested an increase in rent from housing, and essentially their request was denied. Section 8 then told the landlord, well, then you can cancel your contract essentially with a 90-day notice. Can you do that? Is that allowable? That now you've asked for a certain rent increase, housing said no, we don't believe that's the true market rent. We say it's a fraction of that, so you say, you know what, forget it, no more Section 8 here, and you want to cancel the contract.
The short answer is yes, you are allowed to do that. The slightly longer answer is, but you still have to comply with any sort of rent stabilization or tenant protection ordinance. So yes, you could cancel Section 8, but let's take the city of Los Angeles, for example. If that property was under RSO and you canceled Section 8, you would now no longer be receiving Section 8's portion. You cannot raise the rent on the tenant more than the legally allowable, and you can't terminate the tenancy unless it's for good cause. And simply canceling Section 8 is not good cause under the RSO. So you would be stuck with that tenant at an artificially low rental rate, and you wouldn't be receiving the benefit of the Section 8 portion. So if there's an RSO or a tenant protection ordinance in place, even though you're allowed to cancel Section 8 under that situation, you still need to be careful and do the analysis. If I cancel Section 8, am I going to be able to remove the tenant from the property? And if you can't, then there's no point in canceling Section 8.
Boy, LA City is tough, and other jurisdictions that operate the same way. Very, very, very difficult
very
for a
difficult.
landlord. I know that there's some landlords, whether because if it's the way they're bent politically or what have you, that still see this ray of hope that it's going to get better for landlords here in California, that, hey, all these moratoriums and everything, they're going to go away, as we get further away from COVID, the counties, the cities are going to become more pro-landlord. Do you see that realistically happening?
I'm going to answer the question on a two-pronged approach. First, no, I don't see that happening. I see it going the other direction. The county of Los Angeles is a perfect example. They are now looking to take those COVID protections and extend them quite probably indefinitely by linking them to some emergency. And there's always going to be some emergency. On top of that, I do agree that it's going to get better for a certain segment of landlords. And that segment of landlords, admittedly, is larger owners. The regulations are going to become so difficult to navigate for mom and pop landlords that they are going to end up selling these buildings to much larger companies. It's kind of ironic. One of the main reasons we get all this legislation out of Sacramento and out of city council and counties is they say, oh, look at all this corporate ownership. We're trying to get rid of the corporate ownership. But everything they do pushes corporate ownership into a bigger role in housing because the mom and pops can't survive. It's getting so difficult for them that they're just jumping ship. So I do believe that it'll get better for some landlords. For other landlords, I think it's going to get so bad that they're going to end up selling.
And within the court system right now, at the recording of this video, it's March of 2023. Are things speeding up, or is there just an onslaught of evictions that we hear about that it's just daunting and, depressing to be there?
There is not a tsunami of evictions that you always heard about. There was a big wave, let's call it a large wave of evictions came between last April and June, when that deadline for the county's moratorium to kick back in was coming. It is huge influx of evictions. At no time prior to that during COVID was there any tsunami of evictions. And since then, there hasn't been a tsunami of evictions. I don't anticipate a tsunami of evictions coming. I think the numbers will bump up after March 31st, assuming the moratorium expires, but they won't bump up by huge numbers. And as far as the courts are concerned, the courts are facing two challenges. The first challenge is there was this wave of evictions that came through, and it has caused a backlog. The bigger problem that the courts are facing, just like every other business I know right now, is a shortage of labor. The courts are understaffed. They've moved a lot of people around. They had a large percentage of their staff quit throughout COVID as well. And so the courts are facing these same exact pressures as everybody else is right now, and it's backlogging things. I have things traditionally, for example, in Orange County, much easier to navigate than Los Angeles. And I've had things sitting on judges' desks for weeks that normally they'd sign in a couple days, and it's taking 6-8 weeks to get the judge to sign a very simple document that would allow the client to move forward. And again, most of that is just that they're slammed with their staff moving around, their staff shortages. Orange County just hired, I believe it was, they increased the number of UD judges by 5. So they hired 5 new unlawful detainer judges to handle their workflow. City of Los Angeles, downtown Stanley Moss Courthouse recently told my staff that due to the volume, they're no longer answering any questions for unlawful detainers. If you call them to ask them a question, they won't answer. So there is a bottleneck going on, definitely, and it is slowing things down. There are and it gets down to the courtroom level. There's one court in particular downtown that only does half-day jury trials. So essentially, if you think about that, that doubles the time it takes. If a normal jury trial would take, let's say, 7 days from start to finish, this is now taking 14 days at least, because of their half-day jury trial calendar. So there's a lot of challenges navigating through evictions right now.
Yeah, I tip my hat. I don't envy, but I tip my hat to those landlords that are still, they process their own evictions and they refuse to pay an eviction attorney because this is the way they've always done it. I can't imagine trying to do that today with as crazy as things are. Of course, I have a tenant sneeze in the wrong direction, I pick up the phone to call you, Mike, because I'd rather just hand it to the professionals to deal with it, especially in light of how bad things have gotten here lately. So
yeah. It's not pretty. And as I'm sure you know, Chris, there have been several cities just in the last 3 months that have, I'd say probably 5 new cities in LA County and Ventura County that have announced, hey, we're looking into rent control. We're going to do a tenant protection ordinance. So I think it's going to get to a point where the patchwork becomes so complicated for most people. Eventually, probably by county, they'll step up and say, okay, we're just going to implement a countywide, tenant protection ordinance to do away with some of the craziness and the patchwork of laws that we're dealing with. But we're not there yet. It's going to be a while.
Yeah, we had a number of questions submitted for those cities, especially, Pasadena being high on the list. And I know at our upcoming event, you look to cover these things. And of course, you're always available for a one-on-one consultation with landlords to really help them navigate things. So thank you, Mike. I want to thank you for your time. We look forward to having you at our event. And before I let you go, I'm going to ask you this final question that we're asking each of the speakers as we do this interview series leading up to the event. And it's this: what's the number one mistake you see landlords make when it comes to owning and managing multifamily properties?
The biggest problem I see is either trying to use your own homegrown lease or failing to change the terms of the tenancy when you inherit a lease. Let's say you purchase a property, failing to review those leases and change the terms to cap the attorney's fees. In that vein, let me explain a little bit. Anybody who's been a landlord anywhere in LA County knows the name Basta. Basta just announced that they spearheaded the right to counsel movement in Los Angeles. And so they just announced that they will be in every single courthouse throughout LA County.
Wow.
Well, the way Basta works is they will, I won't call it a bluff on every case, but if you have a cap on your attorney's fees provision in your lease, they will bluff you up to trial and then settle. If you have no cap on that attorney's fees provision, they will take you all the way to trial and make it very painful and very costly for you as a landlord. So the biggest problem
let me stop you just one second, just to maybe explain to the viewers. So Basta is basically a tenants' right advocacy group that hires these attorneys on behalf of the tenants for free. Tenants don't pay a dime. And there's a joke. The one and only time I ever went to eviction court in LA, someone told me, "Oh, your tenant hired Basta. You're about to get Bostinated." And I didn't know what that meant. I had no reference. But I soon learned, because they bluffed all the way to a jury trial. Of course, we had a cap on our attorney's fees. So then we settled. And so that's who Basta is. Second point, maybe, Mike, I'll let you answer this one. When you're speaking to capping attorney's fees, I know what you're referencing, but simply, what is that? What should you cap it at?
Sure.
And should it be in your lease?
I should have been a little bit more clear about that. I apologize. In most leases, there's a provision. It's an attorney's fees provision. And it states one of two things. Either it will have what's called a prevailing party provision, or it will have a capped attorney's fees provision. Prevailing party means whoever wins gets their attorney's fees paid by the other side. And that can be a really big number. You're talking tens of thousands of dollars. $35,000 is easily obtained in any jury trial. A capped attorney's fees provision says if anybody brings an eviction or any sort of a contract claim and they go to trial, even if they lose, the maximum attorney fees they'll be obligated to pay is, let's say, $500 is a very standard cap. Some leases cap it at $1,000. I'm getting to a point where, for various reasons, laws that have changed recently, new laws that have come into effect, I'm at a point where I'm telling landlords, just take out the attorney's fees provision altogether. Have no attorney's fees provision in there at all. You're most likely you're going to end up waiving the rent anyway to get this tenant out. So why have an attorney's fees provision in there? You're not going to collect. It's very rare that you're going to use a wage garnishment or something to collect what is relatively a small amount of money, maybe a couple months worth of rent. Take that attorney's fees provision out altogether and specifically state, no, each party shall pay for their own attorney's fees. And that really dissuades organizations like Basta, Eviction Defense Network, Public Counsel from taking the landlord all the way to a jury trial, because they know even if they win, they're not going to get paid some exorbitant amount. And the manpower required to actually go conduct that jury trial is significant for a law firm. So they don't want to spend their resources doing a jury trial when the odds of getting any money out of it are next to zero.
There's no pot of gold at the end of the rainbow. So
Correct.
All of a sudden now they're more negotiable, right?
Correct. Well, they still bluff you all the way to the end, like your experience. And then, as always, they'll end up settling, as always when there's a cap on the attorney's fee.
Well, Mike, that's why we hold this event, because so much is changing, so much is in shift. We want to ensure that the landlords have the right information. So we look forward to you being with us. And again, I want to thank you for your time today. Should the viewers want to contact your office, what's the best way to do so?
The best way is by telephone. It's area code 626-294-0500. That's the best way to get in touch with us. Admittedly, if you're trying to talk to me directly, that's very challenging. I have other associates you can talk to. My staff is very highly trained, but most of the time I'm difficult to get in touch with. I admit that right up front. So if you want to talk to me, you can set a consultation, and we can do it that way. And I'll take an hour of time. I'll review your case. I'll get on the phone with you. That's part of the reason it is difficult to get in touch with me, because I will take that time to talk to people. But like I said, the staff is very trained. There's other associates they can talk to. Just call the office.
Thank you, Mike, and we'll see you soon.
Thank you. I appreciate it, Chris.
I hope you found today's show informative. For those of you that are struggling with tenant issues and you own multifamily properties here locally, be sure to reach out to Mike's office or somebody. Don't allow the issue to continue to persist. Address these issues so that you can gain the peace of mind and reap the financial rewards that your multifamily properties should be providing for you. Our upcoming Apartment Owners Educational Luncheon, the time is now to register. Nearly half of the seats available are already spoken for. The event is only a few weeks away. So for those of you that own in our area of ownership, and you know that you own in our area of ownership because you received a direct invite from me via postcard over the last couple of weeks, we invite you to register now. There is no sales pitch whatsoever at this event. If you've never attended before, and as previous attendees will attest, this is a few hours of all highly educational material from the various areas that you need to be aware of when it comes to apartment ownership, all to empower you, the landlord, so that you can continue to build your financial legacy in multifamily properties. I invite you to be with us, and we serve free lunch as well. Now, if you have not yet, please subscribe to our channel. Be sure to give this video a like if you found it informative. That lets us know what content is speaking to you, the viewers. Be sure to set up the alerts by ringing the bell below so that you are made aware of when we release our newest videos. And be sure to share this video with other landlords you know. You may not be aware of an issue they're having with their tenants, but this information will help them. At least they'll know where to turn, who to turn to if they should have that need. And if you're a newcomer to our channel, be sure to peruse all the videos that we have available. We have over 100 hours now of recorded educational content for landlords like you that speak to all the various areas that impact apartment ownership. We've put it all there for free to assist you in the building of your financial legacy in multifamily properties. And with that, this is Chris German wishing you positive cash flow, tenants who behave, and much protection from Uncle Sam. Till next time.